If you lie under oath and they get all of these medical records and it shows that you had sought medical treatment prior to the work-related injury for the same body parts, you're going to be in real trouble and your case is probably not going to be found compensable.
In Georgia, if an aggravation of a pre-existing condition causes a job injury, can you still collect workers' compensation? Or will your employer try to use common defenses to these situations? This is important information for people to understand if they're injured at work. And we're going to discuss these issues with workers' compensation attorney Sarah Stottlemyer of Atlanta. Sarah, thanks for joining us.
Thank you so much for having me.
So, first off, can you explain the term aggravation of a pre-existing condition in the context of Georgia workers' compensation law?
I can. I think the best way to possibly do that would be to give an example. So, if you had prior to your work related injury, had a back surgery or some sort of back injury, and then you re aggravate that injury while you're at work, say you're lifting something heavy or you fall down, is that going to be compensable in Georgia? In Georgia, it actually is, provided there's a couple things done.
So, how does the law determine if an aggravation of a pre-existing condition is compensable?
So you have to be honest with your employer. That's the first thing you have to do. If you have a pre-existing injury, a lot of times employers will give you what's called a post-hire health questionnaire. That gives the employer the opportunity, once you're hired, to put you in a less physically demanding job. So if you go to that employer and you're filling out the post-hire health questionnaire and they say, have you ever had any back problems? And you say no, and then you suffer an injury to your back and it comes out later that you did have pre-existing problems, they're going to be able to deny that claim if a few factors are met.
So, honesty is really the best policy. What kind of medical evidence is typically required to prove a job related aggravation of a pre existing condition?
So your employer and the insurance company and their counsel are going to request all of your medical records basically for the past 10 or 15 years or so. So anywhere that you've treated, if you have your deposition taken, you are going to say where you have sought any sort of medical treatment. It even goes down to primary care doctors and urgent care. They then request all of those records. So if you are, for example, if they're already questioning whether or not you had a pre-existing condition that was aggravated and you hid it from your employer, they're going to go through and they're going to depose you, which means you're going to be under oath. And they're going to say, have you ever had any problems with your back prior to this time? If you lie under oath and they get all of these medical records and it shows that you had sought medical treatment prior to the work-related injury for the same body parts, you're going to be in real trouble and your case is probably not going to be found compensable.
So, what other common defenses do employers present to argue against this type of aggravated pre existing conditions covering it?
Well, I think a big problem is they will say things like if you have degenerative disc disease, which is just a common term for what we all have as we get older and our back starts to hurt and our discs start to get a little bit dehydrated and a little bit thinner. You know, there's not as much bounce anymore in between the vertebrae. So if you have degenerative disc disease, which is, again, something that's very common for all of us as we get older, they could say, well, look, he already had that. So they would take normal, common, everyday problems and try and say that they were a pre-existing condition. If you have a good lawyer, they're going to fight that and say, we all have that condition. My client wasn't receiving ongoing medical treatment for that prior to the work-related injury.
So, once a claim for aggravation of a pre existing condition is filed, what are the typical next legal steps?
So we would file most likely a notice of claim just to say that we are now on the file as an attorney. You can file a request for hearing, which in Georgia is a WC-14 form, which then will get the defense side to assign counsel. At that point in time, they'll schedule a deposition and they'll start going through to see exactly what kind of pre-existing medical conditions you had prior to the work related injury, and if there's some sort of nexus between the two. In Georgia, it's called what's called the Rycroft defense. And that is where if you had a pre-existing condition or were receiving ongoing medical treatment for a problem, and then you aggravated that problem at work, if you failed to tell your employer and they, quote, substantially relied upon that omission to put you in your job, then that can be a defense that they can say, we don't have to pay you anything or provide any medical treatment for that condition because you failed to disclose it once you were hired.
So, disclosing things is really key here. Based on your experience, are there any common pitfalls for claimants when they're trying to get compensated for aggravated pre-existing conditions?
I think the biggest one, if you have a lawyer, tell them all of your pre-existing conditions. If I come into a deposition with a client and I've already prepped them, I've already said, have you had medical treatment for these issues before? Or what other, things am I going to find going through your medical records? And you don't tell me, that's going to be a problem because I can fix most things. But if you fail to disclose things to your lawyer, then they're going to be caught flat-footed and it's going to go poorly. For example, if you've ever had an MRI and you can later say, well, I forgot about the MRI. I personally have had 4 or 5 MRIs. I've had back surgery and a knee surgery. So you don't forget MRIs. You're put in a tiny little tube. It wheels you back. It's really loud. It takes 2 hours. So it's not something that you generally forget. So I think the biggest piece of advice I can say, if you have a pre-existing condition and you've aggravated at work, 1, call a lawyer because they are probably going to try and fight it. But 2, make sure that you're honest and you tell them everything so they can plan going forward.
I mean, thinking about my own pre-existing conditions, I'd be like, how much time do you have? You
Same.
really have to go back and think about
Uh-huh.
things. So,
Absolutely. I mean, I ended up, when I was 18, got run over by a car. Would I bring that up? I probably would bring that up because it
wow,
did hurt my back. So
absolutely. Is there any other information that you'd like employees with pre-existing conditions to understand regarding workplace injuries?
I just want to make sure that if they do have ongoing problems that they have, which again, once we start to get older, a lot of us get a little bit sore, a little bit faster. Make sure if you significantly re injure it, you immediately tell your supervisor. You don't want to go home and try and walk it off for the weekend because then they'll say, well, we heard you were helping your cousin move a couch over the weekend, and that's probably where you hurt yourself. So I would highly recommend telling your supervisor, making sure it gets documented. And especially if there's anything that you can really differentiate how you felt that morning when you came in versus in the evening. Did you hear a loud pop in your knee or your back? Those things that are really acute in time are going to make a huge difference for your case.
Absolutely. Really valuable information you're sharing with us today. We certainly appreciate your time.
Thanks so much, Molly.
And that's going to do it for this episode of Ask the Lawyer. My guest has been attorney Sarah Stottlemyer of Atlanta, Georgia. If you'd like to ask her about your situation, call the number on the screen. Thanks for watching. I'm Molly Hendrickson with Ask the Lawyers.